Welcome to a virtual session of the 5th DCA for another oral argument session. I'm Judge Edwards. We have Judge Orfinger, and we're pleased to have Judge Keith White, a circuit judge from the 9th Circuit, sitting as an associate judge this morning. So welcome, Judge White.
Good morning. Welcome to you too.
Morning.
Morning.
And,
Good morning, judges.
Good morning.
We have two cases this morning, and we'll take each one separately. Our first case is Ralph Weber versus Albert Esma Ilzadeh, Osler Medical Group, I guess they're out now, and Brevard Orthopedic Spine and Pain Clinic, case number 19-2671. Typically, the way we do it is, appellant, if you want anything other than 5 minutes, let us know. Otherwise, it defaults to a 5-minute setting. The clock there is in one of the tiles that you can see. When you get down to your rebuttal time, it'll flash yellow. Whether or not that shows up well on your video screen or not, I don't know what to tell you. But if something starts flashing the first time, it's your rebuttal time. And when your time is over, it flashes red for both sides. So if you would like, we can do something approaching what was done last night and give you maybe the first 90 seconds uninterrupted. If you'd like to have that, you don't have to, and we can just get into the questions. But in any event, counsel for appellant, you may proceed.
Good morning, Your Honor. May it please the court. My name is Ralph Gonzalez, and I represent the appellants in this matter, Ralph Weber and unfortunately his deceased wife, Mary Weber. If I could try to encapsulate this case in 2 sentences, I would like to try to do that. I'd like to note for the court that on May 16th of 2018 and on July 6th of 2018, after extensive argument on a very broad record, Judge Roberts looked at the issues of this case and found that there was uncontroverted evidence that there was an apparent agency in this case. He also found that there were questions of fact with regard to both agency and with regard to whether or not Dr. Esmelzadeh was an employee of the defendant, Brevard Orthopedic, and I'll refer to it as Brevard Orthopedic for short. He granted summary judgment for the plaintiff on apparent agency. Then, a year later, Judge Earp was hearing the case on August 7th of 2019. And Judge Earp, after hearing essentially the same record, there were a few new documents that the defense had put before the court, but most of those documents had been encapsulated in deposition testimony that had been presented to the court before. Plaintiff had quite a few new documents that we thought added to the record to our position. With that body of evidence, Judge Earp concluded that there was not the slightest doubt. There was no evidence of an apparent agency, no evidence that would support an agency or that would support the argument that Dr. Esmelzadeh was an employee. And so we found ourselves with a complete 180-degree reversal of what had been decided before, and now summary judgment was granted against appellant on all counts. And when I think about the consistency of the rulings of a court and how this happened, I don't understand how that happened. And I'd like to address each of those particular facets. I don't know how much background you want to with regard to the case, because it's really not that important with regard to the actual negligence that occurred. But essentially, Mr. and Mrs. Weber.
Well, I think you can assume that we're very, very familiar with the facts and the issues. What I'd like you to do is address this. It seems to me that there was no dispute, and I'll call him Dr. E because that's so much easier for me, that he was employed by the Back Center. The question really seemed to be who owned and operated the Back Center, and it seemed that the evidence that was developed for the summary judgment on behalf of Brevard Orthopedic was that during the relevant time period, which was January 2011 through March 2011, Osler Medical Inc. owned and operated the Back Center. So that that's kind of where I'm looking at it and coming from. I didn't see any evidence anywhere that Brevard Orthopedic had their name on the building, that Brevard Orthopedic was on any of the business cards or brochures. It was all the back center. And the question was, who owned and operated the back center? And I think that's where Judge Earp wound up heading as well. So that's kind of my take on it, but you approach it how you wish.
Well, Judge, and I think that raises some very good points, because you're correct. The building, the business cards, nowhere was Brevard Orthopedic identified with regard to having the business relationship that was governed, that was being run by these two entities. Everybody knew that as the back center. That's the way my clients knew this organization was at the back center. They went to the back center thinking that they were being treated by physicians, surgeons, and that it was a surgical practice that was being run by surgeons. And that was the entity that they started off with. When I look at the case law on this, I think about the Orlando Executive Park case, where we start talking about the fact that Howard Johnson's had its name on the hotel. But it was being run by a different entity. But it was being run by a different entity from the very beginning before it ever started. They were two separate entities and they had never been together. But this Brevard Orthopedic had been the back center. Everyone considered Brevard Orthopedic as the back center. Nobody thought about Brevard Orthopedic and the back center ever being a separate entity. So when my clients were attending the back center, they were attending Brevard Orthopedic and they thought it was a surgical practice.
Well, I didn't, and again, correct me if I'm wrong, but in Mrs. Weber's affidavit, she talks about the back center. I didn't really see anything discussing Brevard Orthopedic separately. I mean, it's kind of like you go to the 7-Eleven to get your cup of coffee. You don't really know who owns it. You know, it's a 7-Eleven. It sounds like Ms. Weber, we went to the back clinic because the back clinic seemed like a good place to go. I didn't see where she ever discussed, or Mr. Weber really discussed, who owned it or who paid Dr. Esmail Ilzadeh. Sorry.
And that is true, Judge. And there's two reasons for that. Number one, when this case started out, everyone referred to Brevard Orthopedic as the back center. That's the way this case started. In fact, when Mrs. Weber was deposed, there was part of her deposition transcript where she was being asked about certain things, and defense counsel said at the very beginning of that deposition, said, now we've talked about Osler, we've talked about Brevard Orthopedic, we're just going to refer to this as the back center. And that's the way the parties treated this. There was the back center and there was Osler. Nobody used the nomenclature Brevard Orthopedic from the very beginning of this case. And so that was the way this case developed, from the pleadings, from everything else. It was the back center versus Osler Medical.
By the time the lawsuit was filed, wasn't Brevard Orthopedic running the back center again?
Yes, it was. Yes,
and
it was.
During the time of the alleged malpractice, the trade name or trademark of back center had been transferred to Osler, and they even registered it with the Secretary of State, correct?
The fictitious name had been transferred. Of course, there are arguments about whether or not the trademark itself was ever given to Osler Medical. And certainly the biospine yin and yang symbol that was prominent for the back center and for Brevard Orthopedic was never transferred. That was always something that was identified with the back center. Osler never had that. But, Judge, when I look in one of the supplemental authorities that I filed was a patient's right to know. Patient's right to know is that a patient has the right to know who is providing care and who is responsible for that care. And that's why the affidavit of Mary Weber was very clear to say that we thought Osler Medical was something different. They were on a different floor. We thought they were two different entities. We never knew they had any business relationship between the two of themselves.
And counsel, wouldn't you concede that a parent agency doesn't arise from the subjective understanding of the person dealing with the purported agent? It has to be objectively reasonable. It can't be her subjective view. Would you concede
Yes, Judge,
that?
Yes, Judge, I do. I don't, we've never relied on Mrs. Weber saying, I just thought this was Brevard Orthopedic, or I just thought this was the back center. No,
Let me ask you to focus on a couple of things. Your theory here is a parent agency, and I think we all agree that it requires three things: a representation by the purported principal, reliance by the third party, and a change in position by the third party and reliance on the representation. Tell me how the evidence in this case satisfies those three elements.
With regard to the representation was when the clients, my clients, the patient, went to the back center, and it was Brevard Orthopedic.
When they first started, it was Brevard Orthopedic, but did they have any idea? Is there any evidence to suggest that when they first started going there, they knew it was Brevard Orthopedic? My understanding of the evidence was that everybody knew this entity, whoever owned it, as the back center. Kind of like Judge Edwards' hypothetical was, you go to a 7-Eleven, you don't know who owns it, you just know it's a 7-Eleven. I mean, is there any evidence that would suggest that she knew Brevard Orthopedic owned this, and it's really Mr. Weber is the one that was injured, but is there any evidence that either one of them knew that Brevard Orthopedic was the entity that owned it at the beginning or at any time, as opposed to this was the back center?
Judge, I would think that would, if we had said, if Mary Weber had said that I knew it was Brevard Orthopedic, if she had said that, then that would run counter to the whole position with regard to subjective knowledge. I mean, how would she know that? What we're talking about are objective indicators that were out there that third parties could look at. And third parties could look at this and say that Mrs. Weber and Mr. Weber thought that the back center was a separate entity, and it didn't matter who owned it. It was a separate entity, and Osler was something different. They never had any knowledge whatsoever that Osler was involved. If Mrs. Weber were to come forward and say that, well, I had been led to believe that the back center was owned by Brevard Orthopedic, there would be no objective evidence that I would be able to put out there for that, other than her subjective belief that that was the case. That's what makes this case so difficult.
Isn't the issue not so much the fact that Osler Medical was on a different floor? The question is, was there any evidence to suggest that she had any idea that Brevard Orthopedic owned the entity during the relevant time period? Or did she simply know that this was the back center and didn't really know who was? She knew the doctors that were involved in the back center, but she had no idea who was paying their paychecks, who paid the rent, who bought the malpractice insurance, all that.
That's true. And it was very clear from Dr. Dadd's deposition testimony that that's the way they wanted it to be. They wanted the public to think of the back center as the back center. They didn't.
Well, how is that different than the hypothetical that Judge Edwards gave you of the 7-Eleven? I mean, we go to a 7-Eleven and we buy coffee, but we don't really make any inquiry and frankly don't really care who owns the 7-Eleven.
Judge, I understand that, all right? And I think that if someone filed a lawsuit, they would probably file a lawsuit against 7-Eleven, thinking that 7-Eleven was owned by 7-Eleven. They wouldn't believe that 7-Eleven was owned by another company that had nothing to do with 7-Eleven. If it was owned by a Circle K, they wouldn't understand that it was a Circle K. In fact, they would think that Circle K was a competitor, which is exactly the situation that we have here. They thought Osler, and they completely believed that Osler was a completely separate entity. That was a reasonable, objective thing for them to believe. There would be no way I'd ever be able to make the argument There were no business cards that had Brevard Orthopedic, there were no medical records that had Brevard Orthopedic, there were no signs that had Brevard Orthopedic. How would I be able to meet that standard of a objective reliance on information other than some kind of subjective, well, we thought it was Brevard Orthopedic? If my client had signed an affidavit.
I think, counsel, I think that's exactly what Judge Orfinger was asking you. That's one of the first things. The principal has to make that representation, and you just kind of reeled off 4 different ways they didn't make any representation. If Brevard Orthopedic never made the representation, then how did it create an apparent agency?
Brevard Orthopedic made the representation from the very beginning by saying it was the back center. From the very beginning, Brevard Orthopedic was always Brevard Orthopedic, but it told the world it was the back center. And so that was the representation that was made. Our clients relied upon
The only representation your client relied on was it was the back center. And again, going back to the 7-Eleven, if the 7-Eleven is owned on Tuesday by the Southland Corporation and next Tuesday by the Northland Corporation, it's still the same 7-Eleven to me, and I wouldn't care who owned it. Now, if I went to sue it, I would hope my lawyer would figure out who owned it and sue the correct company that owned it. And I can understand there might be some confusion that you'd have to go back through the time frame, but when you look at the paperwork here, you've got the PIA, you've got the agreement to assign, and then you've got the acknowledgement of the assignment of the employment agreement. So I just don't see where you're answering Judge Orfinger there on the representation made by Brevard Orthopedic. I'm carrying you right into your rebuttal time. So,
Judge, if I can just try to go back to where we got onto this tangent, and that was that before the negligence ever occurred on December 7 of 2010, the back center sent out a letter, or Brevard Orthopedic sent out a letter to Osler saying that they were terminating the relationship. And if you look closely at that temporary injunction order that was entered, it was clear from that order that from that period of time forward, the Brevard Orthopedic had essentially withdrawn its participation in that arrangement. It was keeping the revenues from the patients it was treating. It was acting as Brevard Orthopedic at that point. And that's where really the whole agency issue comes in, which presents a question of fact as to whether or not during the time of this negligence, there was an agency relationship because Brevard Orthopedic was running that medical practice. And
I'm sorry to interrupt, but the temporary injunction order, didn't the judge specifically find that no substantial efforts to undo the relationship occurred until just a few weeks before the May hearing?
Judge, that may have been the finding with regard to how the court was ruling in the issues that were presented before it. The question is whether or not factually there were things that were going on at the time that would allow a reasonable person to say that there is a question of fact about whether or not Brevard Orthopedic was managing and directing. Keep in mind, Judge, all along that the belief was that Brevard Orthopedic was actually running the back center. That's
whose
what
belief?
the money was.
Whose belief?
I'm sorry?
Whose belief was it?
That's what Dr. Data testified. And this is going to the agency argument that Dr. Data was saying that basically we were running our own practice and we kept the rights and the ability to run our own practice. And that's what we were doing throughout that period of time. You're
down to 2.5 minutes on your rebuttal time. You may want to.
Yeah, Judge, I just wanted to finish this point about where I believe that once it became clear that Osler Medical was a failed entity, that it wasn't going to survive economically, that the back center wanted to make sure that it survived, it started taking actions prior to December 7 of 2010 to run its practice and to manage its practice safely. And the reason and by doing that, they effectively created an agency at that point, and that's the reality of what was going on at the time. Osler was no longer the main entity that was running that organization. It was Brevard Orthopedic that was running that organization. And those doctors were at the beck and call of Brevard Orthopedic during that period of time because they were trying to save themselves as a viable economic entity. I really think that was actually going on before that time, but clearly by December 7 of 2010, when Osler was failing, that's what they were doing. I'll reserve the rest of my time, Your Honor.
Okay, thank you.
May it please the court, Dinah Stein on behalf of Brevard Orthopedic Spine and Pain Clinic. And just to go right to Judge Orfinger's point, as far as appearances, the record is barren of any evidence that Mr. Weber, the patient, or his wife, Mrs. Weber, had any idea who operated the back center, who employed the back center physicians and medical providers, or cared. That there is absolutely no evidence in this record that they had any idea of who was operating the back center. This is not the situation where a patient walked into a hospital and thought the doctor with the hospital tag was its agent. This is not anything like that situation. There just was no evidence of reliance, actions by Brevard Orthopedic, or anything that creates an apparent agency. As far as the undisputed evidence, and this is, again, Judge Earp he didn't equivocate and said, I'm thoroughly convinced of what the undisputed evidence shows. And that is Brevard Orthopedic at the time of the medical treatment was not providing medical care to patients. It didn't have physician employees. It had no income. It had no contracts with insurance carriers. It had no contracts with Medicare. It was just an entity that had assigned all of its employment contracts to Osler Medical, Inc. That is undisputed. And in fact, we know that happened because the record has evidence that Osler Medical, Inc. was paying Dr. Ismailade. Dr. Ismailade was reporting Osler Medical, Inc. to the IRS as his employer. It controlled Dr. Ismailade's actions. As far as just common law agency, we certainly don't have any elements, any of the three elements of agency in this record. Again, this is what, after hearing all of the evidence, Judge Earp said, I'm thoroughly convinced this is the undisputed evidence. Brevard Orthopedic assigned all of its control, everything, to Osler Medical. And with that, it stopped being the business of operating as the back center treating patients. So that is undisputed, is that Brevard Orthopedic, once it assigned those contracts for the period of time until it got the employees back in June of 2011, had absolutely no say in the dealings of Osler Medical. And in fact, Dr. Hines became an employee. He was the former president. He had been the president of Brevard Orthopedic. He became the medical director of the back center, and Osler Medical, an employee of Osler Medical, Inc. And that's how the decisions were made. As far as the record, there is just no inference that it was anything other than that. Some of the contracts and things, evidence that was provided at the hearing was completely unauthenticated. But having said that, the judge did hear the evidence. He allowed proffers, and the evidence didn't show anything else. So this is, again, there might have been confusion in the beginning of the case when this was first presented to the predecessor judge as far as using the fictitious name, the back center. I think that's what caused the confusion, because we know that Brevard Orthopedic now is the back center, and that's how they've been assigned on the style of the case. And that's correct. But at the time of the negligence in question, the back center was Osler Medical, Inc. There's just nothing in the record to dispute that. So Judge Earp heard the evidence. He heard extensive argument. He considered everything. And again, this was a situation where he didn't say this was a close call. He didn't equivocate. He said, I am thoroughly convinced that the undisputed evidence shows that it was Osler Medical that was employing Dr. Ismailade. And so that was a correct ruling. There's nothing else in this record really to talk about as far as the undisputed evidence. So with that, Brevard Orthopedic would ask the court to affirm the proper summary judgment that was entered in its favor. Thank you, Your Honors.
Judge, if I may.
Gonzalez, we're back to you.
Okay. I wanted to go back to a couple of important facts. On October 23 of 2009, there was a letter. This was something that was very lately produced at the time. There was a letter that was drafted by Dr. Hines as president of Brevard Orthopedic. And this letter was sent, or was supposed to be sent. We never found out, never had the opportunity to find out whether it was actually sent or not. But this letter was drafted, and it's an admission of a party opponent. And it says the board met on October 3rd, and your backlog dictating was discussed. These are the problems that Dr. E was having, timely dictating medical records. And the letter goes on to say, this is a very big issue, as you know, and a considerable liability for the corporation. So in October of 2009, as president of Brevard Orthopedic, he is instructing Dr. Ismail today that what you're doing in the practice of medicine is causing a liability to us. That's the way that the practice was being run. In December of 2009, there was an email that was sent by Dr.
The relevant time frame here is January 2011 through March 2011, correct?
It is, Judge, and what I'm trying to argue is that they were operating as an agency relationship for as early as 2009. That the elements.
Thank you very much. Your time has expired. If you want to sum up very quickly, go ahead.
Judge, I wanted to sum up and say that this is a case where both parties, okay, were referring to the back center as Brevard Orthopedic. That's the way they were looking at this. I'm trying not to misrepresent the record by stating that in the affidavit, they referred to it as the back center, but they were believing themselves that this was Brevard Orthopedic because that's the way that the case had been captioned and that's the way they were running it. On the second part, with regard to agency, these were not two separate and distinct companies. They were being, the back center was intermingling in the affairs of Osler, if you want to call it that. Thank you, Judge.
Thank you very much. Thank you, counsel. We'll be in recess until our 10 o'clock argument.